SJC-09070, Commonwealth versus Daniel Mason.
Ms. Bilger, before you start, it will not bear on our decision, but with regard to briefs, brevity is the soul of wit. So we know we gave you, somebody gave you permission for the length of it, but that should very much be the exception as opposed to the rule. So we read it all, but
I appreciate.
only if you absolutely positively need that length of brief should you do it. But anyway, now you may proceed. In fact, actually,
Stand, Your Honor.
give her a full 20. That's not fair. Give her the full 20 not in any way. That's only for future reference. Okay.
I appreciate the indulgence of the page extension and the allowance. Good morning, Your Honors. Amy Belger on behalf of Mr. Mason. Daniel Mason is a unique defendant who was tried in this case at a unique time in, I would say, world history, United States history, as well as the history of the city of Boston. In those unique circumstances, from both of those perspectives, as they intersect, caused some constitutional concerns regarding his jury and what prejudice or opinions his jurors may have held that we never explored concerning extraneous influences that may have affected.
Can I ask the first sort of preliminary question?
Yes.
The victim, do we have any sense of the victim's national origin?
We do not.
So we don't know, because the victim's name is unusual. What was the victim's name?
Michael Lenz, L-E-N-Z, and then Jean Yazgur, Eugene Yazgur, Y-A-Z-G-U-R.
And then there was Samson.
And
That's the dog.
I know.
so is there any indication that we're dealing with different nationalities or different religions here?
It's not in the record, but I believe that the law is clear that this claim exists outside facts along those lines,
Well,
because
it wasn't asked for.
it wasn't asked for.
You're
This
asking the judge to do the sua sponte, in other words. You're saying that
Right.
she had an obligation to do the sua sponte.
yes.
And where do you get that from?
I get that it's a statutory obligation based upon the constitutional rights at issue.
Didn't she ask about potential jurors' bias as a result of media stories to which you point?
I believe that doesn't quite capture it in terms of this case, because media stories, it was asked about in terms of the crime itself, not about in terms of the defendant and the unique aspects of the defendant, which gives rise to concerns of racial prejudice, profiling, opinions, that may be the type of racial prejudice or animus or highly charged political opinion that could affect our jurors' ability to be fair and impartial. I think in the record, it isn't addressed at all. But if you,
Do we know what the reporting was about this case?
oh yes, it's in the record appendix, we
Doesn't
do.
it talk about him at all?
It does. It talks about him very
So
extensively.
didn't the judge ask whether they had seen any of the reporting regarding the case and if they'd formed any opinions about it? Didn't she ask him that?
But I think that the reason the law requires that we explore whether there is the potential for racial discrimination is for a reason. And that wasn't explored. And it was extensively reported about Daniel Mason being a trained assassin by the Israeli military.
But how is that, I mean, your connection to 9/11, he's not a Saudi national, right? He's an Israeli. I think that's why it took you 60 pages to, make all those connections. But I mean, I just don't see how this, unless we're talking about just generic prejudice against Israelis or people of Jewish origin, I don't see why this is a 9/11 problem.
And the reason it took me 60 pages is because under Restaino, you have to show, special circumstances that are very closely tied in and tailored right for the claim. And the reason I say that an Israeli IDF soldier stands in the same position and is of the same level of concern as, say, a Saudi, right? Or in the California case, where 25% of the juror pool in California that had no direct connection to the 9/11 attacks, 25% of the jurors raised their hand when an Egyptian defendant was voir dired over this. The reason is because, and as I explain in the history and the record, is this is the most divisive and volatile type of subject matter in terms of media, controversial media reporting that this country has ever seen. And you have people who suggesting that if Daniel Mason was a Saudi, there would be more of a concern than if he was an Israeli, is framing the problem and looking at what happened from a certain viewpoint. There are many, many people, as the media articles show, that looked at it from the viewpoint of this was Israel's fault. And this was specifically the IDF that was demonized, right? Because you had the IDF being accused and widely reported of slaughtering Palestine children. And this was right around the time of the trial. So the very close tie-in to prejudice for Daniel Mason is that, and it did take extensive briefing to flesh this out, but it was for this reason, that there is a statutory obligation for a judge to look into this and probe into this before putting a defendant like this on trial, having him stand trial, when there is that kind of potential racial prejudice and animus that could present itself in the jury pool, and especially in Boston at the time that this happened. If in California...
Why especially in Boston? Because one of the flights left from here?
Because the flights left from here and the terror cell centers appear to have been here. And because of that, if juries are getting flushed in California for an Egyptian defendant simply because a judge thought to ask the question, or the attorneys requested in the court, granted a request to ask the question about whether anybody held any prejudice because that defendant was Egyptian. And by the way, that Egyptian defendant was not tied in to the case in any way other than the fact he was Egyptian born. Daniel Mason, he's not only Israeli, he's from an elite Navy unit in the IDF, and he had been widely reported in the press to be a trained assassin from the Israeli
But the
military.
jurors were asked about the press, about him. That's
They
the point.
were, but again, it's...
That's not enough. You can't have it both ways.
I think I can, in the
Fine.
sense that the reason I think I can have it both ways, and I think there's actually only one way when you look at the freestanding right to have jurors who are free from racial
Yes, the
discrimination.
question about did they see the publicity? And the ones who said yes, presumably were excused.
But if they weren't asked, and did you see the publicity about him being a trained assassin from the Israeli military,
Why do they have to
that's a
ask it
question that
directly?
needed to be fleshed out.
Any publicity about him. Any publicity about him is what they were asked, right?
There is, yeah, it's about him specifically, being a trained assassin.
They asked about Israel too, huh?
Yeah, and it was also,
But I'm sorry, I'm a little bit lost. I gathered there was testimony that your client told somebody he was a trained assassin, which came in at trial, correct?
yeah, but it was also the prosecutor from the DA's office who was interviewing and saying that he was a trained assassin.
Interviewing, mean in the press?
Yeah.
Okay, but if the
Yes.
jury didn't hear that, what consequence would that have?
Well, it was reported in the media, and there was no voir dire on whether any of the potential jurors were aware of that. So that is something.
But just answered Justice Lang to say that she did ask the usual question of whether you've heard anything about this case or anything. or do you know
Anything about this case, but not about the defendant specifically. That's what I'm saying.
You haven't heard anything about the case. You haven't heard anything about the defendant specifically.
I think it's a distinction between typical voir dire is if you've heard anything about this case, this crime, these charges, the incident. What I'm saying is the missing voir dire that the defendant was entitled to and needed to have a fair trial was the defendant as an IDF soldier, as a trained Israeli assassin.
That would have been part of the publicity about the case about him, right?
But also,
Why would they have any publicity about him that didn't have to do with the case?
that publicity, why would they have any publicity about him?
Yes.
To be inflammatory.
No, I'm saying, why would there be publicity about him separately from his case? If she asked about his case, it of necessity encompasses him.
It does. But the specifics in the press before the trial about who he was in terms of his status from the IDF was inflammatory reporting.
Right,
So,
but they didn't see it. So I think your point is, I think your point is, if they didn't see it, we're not worried about the press. What your point is, you wanted voir dire about the jurors' reactions to a defendant who is a trained assassin, Israeli assassin, right?
both, yes, both. And I think that
You
that,
really wanted those questions asked?
yes, I did, because when I look at people raising their hands in California over an Egyptian saying, yeah, no, I don't think so, and it specifically tied into the 9/11 attacks,
Right,
yes,
but-
I do.
But I mean, you know, and I don't mean to minimize what you're saying, but they weren't picking up Israelis after 9/11. They were picking up Egyptians and Saudis, and so it's a different, 9/11 created a different dynamic. I understand that it may spread to certain people that they're blaming Israel for this, but it's just a different dynamic than what you're describing. You know?
But it's very easy to ferret out with those questions that go to racial discrimination and racial bias, just to ask, because there certainly were people, given the media coverage at the time, who blamed Israel.
But again, it wasn't requested and,
It wasn't.
So if it had been requested and denied, then you'd have, I could see the argument, but the judge didn't think of it, neither did the defense counsel.
That's true. But the reason we have the statute that says that there's an obligation, right, to ask, if there's any possibility that racial discrimination and extraneous influences that may bear upon subject matter like this would interfere with the defendant's right to a fair and impartial jury, that's why that statute is there for when it's missed, right? It puts the obligation there. So I would say defense counsel was ineffective for not asking for it, and it was an abuse of discretion for the judge to not give it. And if I could, I'd like to...
But isn't our case law is that, as recently as Justice Lang's opinion about a year ago, that it has to be asked for, that it's error only if it's asked for and denied, as opposed to you would be asking us to say it's error even if the defense counsel does not ask for it?
Well, I think in a situation like this, when you have a statute that mandates the court do it, it can be found to be an abuse of discretion not to do it. And I would also say under 33E as well to look at this and what would be a fair trial.
What is the statute that mandates in these circumstances that these questions be asked?
The statute is General Law, Chapter 234, Section 28. It says jurors must stand indifferent if it appears considerations may cause a decision upon issues extraneous to the case, community attitudes, exposure potentially to prejudicial material, or preconceived opinions of certain classes of persons. The jurors may not stand indifferent. The court shall, or
But if
the
it
parties
appears,
may.
so if it appears to someone,
Yeah,
right?
the court shall. So in 1979, this statute was changed. It used to say the court may and made it discretionary for the trial judge whether or not to ask those questions. In 1979, the word may was changed to the word shall. So it makes it mandatory.
But the logical premise of your argument is that even if defense counsel does not ask for it, a judge must ask a jury about whether there is any prejudice against African Americans, against Muslims, against Jews.
If the judge is on notice that that may come into play in the very specific case, and this trial judge was, because on October 30th, jury empanelment started on the case on December 21st. So on October 30th, 2 months before, the prosecutor filed a motion saying he wanted to bring in all the evidence of Daniel Mason being, having his Israeli military background and his training. So the court was on notice, and the parties were on notice, that this was going to be an integral part of the Commonwealth's evidentiary presentation that the jurors were going to hear. It distinguishes this from Martinez, where none of those issues were decided before, so how was the trial judge to know what we needed to voir dire on? Here, the trial judge did know because the motion was filed and it was on notice. And when you have a statute here that mandates it, and when you think back, this is very soon after 9/11, and the prosecutor is putting everyone on notice. He's going to be talking about Daniel Mason as this trained IDF killer. It is something that he had a right to have jurors examined to make sure they weren't going to harbor any.
I mean, there are a number of defense counsel I can imagine who would not want the jury to be voir dired about, do you have any feelings about somebody? Since that came in only because there was one statement he made to one person which came in. But if you do a voir dire and you bring people to sidebar and you say that if at trial it will emerge that the defendant was a trained assassin with assuming he was, with the Israeli Defense Force, I can see a number of defense counsel saying, no, thank you. I don't necessarily want that to be the impression which is embedded in them by the court, where I'd much rather have it come out at trial, and I can question whether or not in context it's credible, or whether he was blustering or whatever else. But I mean, you're asking us to sort of say the judge is obliged to give something which defense counsel didn't ask for and may not have wanted.
Well, it's certainly a flag, right, that there can be an extraneous influence that is racial in nature. So for the court to not even inquire about that, and I think there's also a view of it that it's manifestly unreasonable to not want to ferret out people who would admit to that type of a bias ahead of time. It wasn't like there was any question of how bad it was going to be in terms of an argument by the prosecution. It was significant identity type information that they needed to put in a circumstantial case to prove he was the killer, or to try to prove. So, I think that aspect of it, for the court not to have raised it at all, is certainly a problem under the statute. And I don't think that would be a manifestly reasonable thing for a defense attorney not to want to have jurors challenged for cause that could immediately say that they couldn't give him a fair trial based upon what they were inevitably going to hear. And in terms of the second issue, in terms of the juror, I know I just have a little bit of time, but I just wanted to say there is not any articulated reason for why, when the judge asked the prosecutor to articulate a reason why he was striking that juror, and then the judge finds the reason not to be accurate in terms of the record, to not inquire further before allowing that peremptory, and the facts and circumstances of that challenge.
But your sister notes that the prosecutor did not strike this particular juror initially. It was only after she raised her hand and said she was concerned about her ability to get coverage that he struck her.
But I think that what prompts the inquiry from the court is it is immediately after the juror is excused because she has to travel to Plymouth for Hanukkah, and it's immediately after the defense attorney points out that the case is going to be steeped in Jewish traditions and experience. It's immediately after that. So, and if you look at who the prosecutor didn't strike and didn't have a problem seating over work hardship, right, and things in their life that made jury service difficult. If you look at Clayton Correa.
But she's a doctor, right? She's a medical student. I can't remember what she is.
She's a medical student.
She was more advanced than he was. She was a resident.
So
wasn't
she's
I don't know.
she's a busy, super busy person, right? You know, she's one of these type of resident types who are working 60 hours a week or whatever they put these people through.
But she
Does
said
that make her a little different?
It doesn't when she says she wants to serve. She said she wanted to be a juror in the case. You got Clayton Correa, right? Go back and look in the transcript. And he's practically, jumping up and down about how this is going to ruin his life. This jury service is such a hardship. And he can't do it. And he's 16 hours a day caring for the elderly and the combat vets, and no one else can do it. And, he's fighting with the judge. And the prosecutor's fine with him, making him serve, right? And, then you look at Peter Falvey, who's running his own financial services firm. He's begging the judge to excuse him. The prosecutor's not challenging him. Now we got Ronit Friedman. Okay, she's fine at first, then the defense counsel brings up the case is steeped in Jewish tradition, and she comes up and she says she wants to serve. The only thing is she's got this medical rotation, so the judge says, we're going to have the clerk call Beth Israel. That's not your problem. We're going to have the clerk call. We're going to take care of it, okay? She says, okay, right? So then he strikes her, and the judge says, wait a minute, what's the reason you're striking Ronit Friedman? Oh, well, she had a problem with being here. She had work hardship. The judge said, no, she didn't. And he said, well, I'm just not comfortable with her. Okay, no.
That's
At that point,
he didn't say he was not comfortable with her. He said he was not comfortable with the fact that she had she had a work issue.
but there's the problem. She didn't have one.
Well, she didn't want to. Well, she certainly did have a problem in some sense.
She said she wanted to serve, and when the judge said that they would call Beth Israel for her, she said, okay.
Okay. Well, I think your time is up. Thank you.
Thank you.
Ms. Campbell.
Can we talk about the last part first?
Absolutely, that's where I was going to start.
Oh, good.
Before I do, good morning, and may it please the court, Kaylin Campbell on behalf of the Commonwealth. I'd like to acknowledge Mr. Gene Yasger, who's in the courtroom today, and Michael Lenz's family, who is watching via webcast. We ask you to affirm the convictions against the defendant for this senseless and brutal murder. But let's start with that juror issue, and I think it's important first, defense counsel didn't object. But second, I disagree with my sister's recitation of what the facts are. Specifically, in her reply brief, she takes issue with the Commonwealth citation of the word problem. But if you look at transcript volume 1, page 78, it's the judge herself that says we have a problem with juror in seat number 13. And for about the last 2 minutes, my sister has just been up here and said the name Ronit Friedman over and over and over again. That name was said once when the juror was first called up. She is then referred to as either juror 314 or the juror in seat 13. I'd also argue, as I did in my brief, that we can't make any assumptions based on what her name is. We can't assume that she's either Jewish or from Israel.
Let's assume we can. Let's assume we can.
Okay, even if we assume that you can.
Okay.
Even if we assume that you can, I'd like to say, particularly that it's not as if her name was being repeated over and over and over again. But even more than that, if you look at transcript volume 1, pages 91 through 92, that's where the prosecutor does explain the reasons why he's now wishing to use a peremptory against this juror. And it's because though she was seated and the prosecutor did not exercise a challenge on her the first time that she was seated. She then had enough of an issue that she got the court officer's attention and asked to be brought back up to sidebar, which she brings up the fact that she is a resident and that she's starting a night rotation.
How do we distinguish her from this guy, Clayton Correa, which the prosecutor seems to...
Your Honor, I'll stop you before you get there because the prosecutor actually exercised a peremptory against that juror.
Oh, he did?
Yes, and that can be found on transcript volume 1, page 59.
Okay, so how about, so your sister's argument is essentially that the prosecutor was tolerating other people with work problems. Why don't you address the bigger, why don't you address that issue?
That issue? So as to, and I'll refer to him as juror 1-5, but that is Mr. Correa. The prosecutor did exercise a challenge against him. That's on volume 1, page 59. So I'd say that completely cuts out defense counsel's argument as to him. As to juror 210, and this is on volume 1, page 46 through 47, he said that it would be crippling to him. He ran a financial firm, but then he also explained that he had 7 employees who worked for him. And so I'd say there's a difference there where you have employees who work for you as opposed to you being worried that, I would say a medical residency is distinct in that way, and that it wasn't as if that work, if she couldn't, with juror 314, let's say she couldn't find coverage, she would be at the hospital all night and then having to report to jury service at day. The same is true of juror 6-6, which is transcript volume 1, pages 96 through 97. This juror spoke first of financial hardship, but then said his work hardship was that he had to learn new software for the tax season, and this happened at the beginning of December, not, sort of at the height of when tax season was. I'd also say that juror 3-4 can be distinguished from these other jurors in that she had enough of a problem with it that she brought it to the attention of the court officer, asked to be seen, asked to have this issue specifically addressed. And I disagree with my sister's contention that the judge didn't accept the prosecutor's reason as adequate and genuine. He first gives reasons why. She says, I don't agree that's what the juror said. Then he says, my concern is that she expressed a problem with being here, and that's why the reason for the request. I'm reluctant to have somebody sit who has expressed that type of problem, and that's on volume 1, page 91 through 92. The Judge McAvoy says, all right, you may challenge her then. And there was no objection to this challenge. I think that's key in light of sort of what had happened before, which was that the juror who had expressed that she couldn't sit because of obligations due to Hanukkah, when that juror when they were discussing excusing her for cause, an objection was raised to that.
Page number on that? Can you have the page number on that? You have the page number on that one?
The Hanukkah?
Yeah, the Hanukkah.
I have the transcript right here. Actually, thanks to my sister, it's 6 pages, volume 1, 68 through 70.
Thanks.
But I say in that instance, the defense counsel had no problem objecting, making his concerns known on the record, and he didn't do that with this juror. So for all those reasons, I'd say that the peremptory challenge against this juror was perfectly fine and at any rate didn't rise to a substantial likelihood of a miscarriage of justice, given that there was no objection. Turning to the first issue, I think the critical part is that defendant didn't ask for any of these questions to be asked of the jury venare. There were questions about the media, and that's in transcript volume 1, pages 13 through 14. I think we would be, Justice Budd, I think you said it correctly, where we would be in a different position if this was asked for and it wasn't given. I think it's enough that there's a question about a media. The media coverage unquestionably mentioned the defendant and his service in the military. Nobody who was seated brought up that they had that type of knowledge. They were also asked about other types of bias that they held in this case.
You also asked them, are you aware of any bias or prejudice that you have towards either the defendant or the prosecution?
She did.
Yep.
She did. In specific, if there were concerns about the media and how it related to 9/11, before the jury heard any evidence in the case, and this can be found on volume 1, pages 105 through 106, the judge does give a specific instruction about media, and she references 9/11 specifically in the unique period of time that this country was in, that it may be hard to sort of shut off or ignore or not talk about things given that 9/11 had just happened, but that they must. I'd say, given that instruction too, that there was a specific focus on this, that, you know, that allayed any sort of ongoing prejudice that may have occurred. Every day there was a question about media coverage and asking the jury to raise their hand if they saw any, and none raised in the affirmative either.
How about, there's a lot of questioning about the prior assault and the prior civil case. Sort of an unusual amount of information is put in on these two. It's not just that there's a verdict against him and the next day he kills but it's like a detailed description of both cases according to the 134-page brief, but I haven't read the transcript yet.
Correct, and I disagree with that characterization. This evidence was relevant to show both motive and the...
I don't doubt that it's relevant evidence. The question is how much of it was thrown in.
And I think the actual details of the assault itself, the only witness who offered testimony about the actual details was Mr. Yasker. As to the other portions of that, there was both a criminal prosecution. The ADA who handled that criminal prosecution testified, but she merely testified that it happened, the dates that it happened, who testified, and what the result was. Similarly, the defendant's civil attorney was called to testify. He testified as to the day the civil judgment entered. He testified that it entered, who was in the courtroom, and that was important because the defendant made a statement on that day that Mr. Yasker would never see a penny of the judgment. And then there was other testimony about the execution of that civil judgment, which was on March 1st, which was the Commonwealth's theory was that was the triggering event for the murder. And I think it's important too because
Murder is on March 2nd, right?
it's at 5:38, around early morning hours of March 2nd, correct? I think it's important because the murder happens 3 years after the original assault and battery, so it shows the timeline and the continuing sort of progression of this and the continuing hostility. Without it, motive that someone 3 years later would then go kill someone for assault and battery that had happened sort of not in the same temporal proximity is not the same. There was a limiting instruction given by the judge when the evidence was first entered. That was when the prosecutor testified. It's in volume 2 of the transcript. It's the exact page is written in my brief. I don't have it at my fingertips. But there certainly was a limiting instruction which the jury is presumed to have followed. I'm happy to answer any other questions that the court may have. But if there are no further questions, this is a case in which the great weight of the evidence established that the defendant was the individual who, dressed as a ninja, broke into the victim's apartment and with the precision of a marksman shot them and Samson the dog. The defendant had the motive, he had the opportunity, and he exhibited consciousness of guilt. This is an overwhelming case in which this court should not exercise its authority under 33E and reduce the verdict, and it should affirm all convictions against the defendant. Thank you.
Thank you.